before events dictate. It has nothing to do with opinion. It has only to do with the ruthless quest to see what is rather than what you prefer. That's all it is.
So clear, right? Hi again, everybody. It's 5 o'clock in New York. A fundamental misunderstanding of U.S. intelligence and its products by ex-President Donald Trump should alarm every last one of us, especially as he is currently the presumptive Republican nominee for president in the 2024 election. Because if he does manage to return to the White House, if he prevails, individuals like Sue Gordon, the former principal deputy director of national intelligence, people who value the intelligence itself and the people who collect it above any president's personal political agenda, people like that won't be there. They won't work for the country. Trump and his loyalists wouldn't have them. He will use and handle the intelligence he receives as president only in ways that benefit him, in ways that he wants. It's a concept underscored by the fact that Trump was charged last year with 37 counts of mishandling classified documents, crimes, including willful retention of national defense information and obstructing efforts by the government to get those documents back. More crimes. The case originally was scheduled to go to trial this past Monday. It has now been indefinitely postponed by the judge overseeing it, Trump-appointed Judge Aileen Cannon. But the case just saw some huge new revelations to us in the public in a newly unsealed opinion written by U.S. District Judge Beryl Howell back in March of 2023. Judge Howell describes, quote, strong evidence that the former president intended to hide boxes from his attorney's search efforts to comply with the grand jury subpoena and resultantly unlawfully to retain any classified documents contained inside any of the boxes purposely removed from the attorney's search. The judge called out the ridiculousness of how Trump's attorneys discovered 4 more classified documents at Mar-a-Lago months after the FBI searched the property. Quote, notably, no excuse is provided as to how the former president could miss the classified marked documents found in his own bedroom at Mar-a-Lago. And there was this significant finding that exposes potential further obstruction of justice by the ex-president. Quote, the government urged that this scramble to Mar-a-Lago in the wake of the January 24th, 2022 phone call reflects the former president's realization that the removal of the boxes from the storage room before search was captured on camera and his attempts to ensure that any subsequent movement of the boxes back to the storage room could occur off camera. Also unsealed, along with Judge Howell's ruling, new images of Donald Trump's criminal co-defendant and personal aide Walt Nauta moving the boxes of documents around. Nauta was in court in Florida today. Judge Aileen Cannon heard his 2 motions to dismiss the case, but ruled on neither one of them, a pattern for her. Another example of her delay tactics when it comes to bringing this case to trial. A case, we remind you, Trump's own former Attorney General Bill Barr said was a legitimate one and said Trump engaged in, quote, outrageous behavior where anyone would be prosecuted. It's where we start the hour with some of our favorite reporters and friends. Former FBI counterintelligence agent Pete Strzok is back with us, plus national investigative reporter for the Washington Post, our friend Carol Lennox here. Former top national security official at the Department of Justice, Brandon Van Grack, is here. And joining me at the table, NBC News correspondent, my friend and colleague Vaughn Hilliard is back. Let me start with you, Carol Lennox. We are learning about this from a newly unsealed filing, but it's not new information. It's information about all of the many, many layers of criminal obstruction Donald Trump engaged in. Tell me your reaction to reading these new revelations.
Well, I think it's so smart of you, Nicole, to highlight that it's not new information, but it's new to us. It's not new to Jack Smith, and it's not new in large measure probably to Donald Trump. But as you get closer to a potential trial, and obviously this trial is some way off, but as you get closer and there are pleadings and fights over what can be entered into evidence and whether or not the case can go forward at all, there are going to be fights and there are going to be revelations of unsealed motions. New things are going to come out. And in this one, I think it's just, you know, a little bit of the icing and the cherry on the cake about the claims of obstruction that Jack Smith's team has made about Donald Trump's effort to not turn over the records for months and months and months that were highly classified. Then his attempts, once he found out there was a subpoena for them, to conceal them and work with at least one very important valet and aide to him to hide and move the boxes to his personal residence and to other places away from the storage facility where he was going to authorize his attorney to do the search of the records. His attorney was in the dark, Nicole, remember, when he agreed and arranged with former President Trump to come back and look at that storage locker, review all of the records, what he believed were all of the records. Actually, many had been removed by Donald Trump at his instruction and by his aides and moved back after key documents had been removed so that the lawyer wouldn't find everything there really was. And this was additional evidence of Donald Trump trying to avoid being caught on camera, at least his deputies being caught on camera making these moves.
You know, Brandon, the obstructive acts in the Mueller investigation were so vivid and so startling. They make up, I think, an equally lengthy segment of the Mueller report, right? Volume 2 is as long as Volume 1 on Russian collaboration. I want to ask you about the substance of this footnote from Judge Howell. Quote, relatedly, on January 6, 2023, the former president's counsel informed the government that in 2021, witness whose name is redacted scanned the contents of the box produced on January 5th, 2023, and previously containing classified documents onto a laptop in her possession owned by the Save America Political Action Committee, a PAC formed by the former president in 2020. The former president's counsel saved those scans onto a thumb drive and provided the thumb drive to the government that day. It seems to me that we might never know how many people actually touched classified material, where they went, who saw them, who scanned them, who had a thumb drive. I mean, are you confident that the government has in its possession a real sort of assessment of where all this material has been?
No, and I don't think the government thinks they have a level of confidence. I think it explains some of the scramble that I think we saw initially in this case, where there was concern that there was material that the FBI had not seized at Mar-a-Lago. There was other classified documents, and now we're getting more visibility into why the Department of Justice and the FBI were so concerned. And I think it underscores sort of the importance, or maybe even the contrast of the opinion from Judge Howell in D.C. that was just released, because that opinion was a judge in D.C., an experienced judge, who found the conduct here so disturbing that allowed the Department of Justice to ask the former president's attorney information, because the judge ruled that it appeared that it was furthering something criminal. That is rare. That is a big deal. You now have a judge in Florida that has seen even more information than that judge in D.C., and you don't see that level of sort of indignation or sort of affront from the court. Instead, what you see is extensive hearing after hearing after hearing on various motions, including the ones today on selective and vindictive prosecution, even though that opinion that you just read showed sort of how not vindictive and selective, but how targeted and justified the conduct was.
Well, and let's not leave that out there, because I think the Trump side of the ledger would have you believe that there's some political variable. There's not. How many cases involving classified documents has Judge Aileen Cannon ever presided over? How many trials?
Well, none, and it's rare. That's in terms of the equivalence between Judge Howell in D.C., who has extensive experience sort of on some of these issues, versus the judge in Florida. And part of this is to underscore your point, and it's been talked about. There is overwhelming evidence that classified information was stored in Mar-a-Lago, where it was not allowed to be, and was not produced to the government. What was released, or unsealed, I should say, just furthers that. And as Carol indicated, it's not new. Judge Kennan has seen that, and yet, and I think this is part of the curiosity, the judge appears to have some sympathy, sort of believe that there's some merit to some of these really salacious, sort of outrageous claims that the former president and the defendants are making, including the ones that occurred today.
Are there any factual pieces of evidence to underscore the salacious claims that the ex-president is making?
Well, so I mean, let's focus, in fact, on the hearing today. So the defendant Walt Nauta said that this was selective and vindictive prosecution and should be dismissed. But in fact, it appears at the hearing there is an acknowledgement. Well, actually, there's no evidence that the Department of Justice was vindictive towards the defendant. The closest they came was a disputed conversation with respect about Walt Nauta's attorney, counsel. That's the closest, and it appeared that even his counsel acknowledged that this wasn't sufficient. And I say that because Judge Kennan didn't need a hearing to rule on that, or I think sort of the reaction would be, even if these types of arguments, selective prosecution, can be made, it's oftentimes on the papers, a judge can see that there's just no evidence of selective or vindictive prosecution and just rule in the papers. But instead, there was a hearing, not even combined with other issues, a hearing specifically on this point, which just goes, I think, further evidence that this court really finds something very sympathetic about these arguments that they're made, even if there doesn't seem to be evidence to support them.
I mean, Pete Strzok, there is evidence of vindictive conduct. It's from Donald Trump, and it's all on tape. Let me play this. It's in the indictment.
Except it is like highly confidential, secret. This is secret information. But look at this. And you know, he said he wanted to attack Iran and what? These are the papers. This was done by the military, given to me. I think we can probably, right?
I don't know. We'll have to see. Yeah, we'll have to try to
Declassify.
figure out
Yeah. See, as president, I could have declassified it. Now I can't, you know, but this is classified.
Now we have a problem.
Isn't that interesting?
Yeah.
It's so cool.
Pete Strzok, the person who is vindictive when it comes to the country's national security apparatus is Donald Trump, the charged individual. And I guess my question for you is, how do you tell people to, how do you make sure people understand that what's under assault here is the government that Donald Trump ostensibly led, was supposed to lead? The person who benefited from classified material we didn't know how we benefited as citizens. The people who benefited were the politicians and the leaders who had access to it. It was Donald Trump. And